appeal in the matter of National House Building Council and Peabody Trust.
Yes, Mr. Grant, I can tell you that we have read the judgment, we have read the skeleton arguments, and we have read the policy.
Thank you very much. May it please my lords, I appear with my learned friend Mr. Harry Smith on behalf of the Appellant NHBC, and my learned friends Mr. Casey, King's Counsel, and Mr. Mesfin appear for the respondent,
Yes.
Peabody Trust. And your lordships will have seen that this is an appeal from the decision of Mr. Andrew Mitchell, King's Counsel, declining to strike out or grant summary judgment in respect of a claim brought by the respondent claimant for indemnity under a policy of insurance in common form, I should be clear about, issued by NHBC. And my lord, when Lord Justice Coulson granted permission to appeal back in December of last year, he respectfully rightly noted that the appeal raised important questions concerning the meaning and application of a common form policy, which is, no doubt there are many hundreds, if not thousands of them issued or have been issued.
Yeah.
We would go on to say, respectfully, that it also raises, as an appeal, important questions concerning the larger issue of when causes of action in respect of policies of indemnity insurance accrue. And my lord, we suggest that at the heart of this appeal there is one key issue, and that is when a cause of action accrues in a policy of indemnity insurance, and in particular when a cause of action accrues in respect of this particular policy of insurance. And let me say immediately...
There are two questions on that. One is, when does it accrue as a matter of generality? To which the answer on the authority seems to be when the event insured against takes place.
Quite.
And then the second question is, what is the event insured against under this policy?
Quite. Absolutely right, my lord. And we say that there are very simple and clear answers to both those questions, which were plainly before the court below. And indeed, my learned friend and the evidence on which he relied had articulated a very clear case on that. And indeed, that's now been fortified, as we'll go on to see.
But the real issue here is, what is the event insured against, isn't it?
Quite right. And I'm going to come on to that, I hope, with gusto.
Yes.
No
doubt you will.
In due course. My lord, let me say one thing very clearly now, that nothing on the application that was made before the learned judge below, and nothing on this appeal, requires your lordships to, in any shape or form, arrive at findings of fact that are contrary to the claimant's case. The application that was advanced below, the appeal that is advanced in this court, is premised on the facts as pleaded being correct. That's, of course, a premise which is controverted in the defence, but as is common form and usual, for the purposes of testing the question of whether the claim had been brought in time, my clients were content to accept and bound to accept realistically on a summary judgment application that the court should proceed on the basis that the evidence given advanced by the respondent and the facts pleaded would be decided in their favour at trial. And we say, notwithstanding that premise, it was clear and should be clear to this court that the claim that was issued by way of a claim form on the 24th of July, issued on the 24th of July 2023, was out of time because it was clear to the standard prescribed by the summary judgment or the strikeout criteria that the claim, that the cause of action, I should say, had accrued on a date prior to the 25th of July 2017, and therefore it followed that this claim should be dismissed. Now, my lords, I said a couple of minutes ago that subsequently to the argument below, subsequently to the judgment of Mr. Mitchell, the parties have pleaded out their claims further. My clients put in a defence in the bundle. My learned friends have joined with that defence via their reply. And what they've done, as we'll come on to see in due course, is they have pleaded out very clearly what they say the correct limitation analysis is. And of course, that depends upon what they say as the correct analysis as to the accrual of the cause of action. It's set out very clearly. And in one sense, the only real issue before this court is whether the plea at paragraph 7 of the reply, which sets out 3 variations on a theme, all with a common thread, is whether that plea is correct or not. And I'll come on to look at the reply in short order. My lords, you've read the policy, and I'm grateful for that. I will spend, if I may, just 5 minutes on the policy, just because there are some aspects of it which may benefit from a certain amount of exegesis, if I can assist the court in that way. My lord, we find that at tab 13A of the core bundle. If we turn to page 123, your lordships will see, this is the first page, the Buildmark choice policy. Your warranty and insurance cover applies to newly built social housing properties registered with NHBC from a given date. And my lords, if we go to page 126, we will see under the warm heading welcome, we will see at paragraph 2, this document contains the terms and conditions of Buildmark choice, which is a legal agreement between you, the contractor, and NHBC. I will come back to another paragraph at 126, but in order to do so, I'll turn first straight to the relevant cover in issue in this case, 134, as your lordships will have seen. And your lordships have read that, I'm grateful for that. And you'll see it's in short form, option 1, insolvency cover before practical completion. And we see under the little box at the top when this section applies. And of course, the words, you have to pay more to complete the building of the homes because the contractor is insolvent, lie, of course, at the heart of this claim. My lords may have seen that there is a good deal of contestation concerning the meaning and application and implications for the primary issue to be gleaned from other paragraphs or sentences within option 1.
Just before we go to other sentences, can we just look at page 142?
My lord, I was going to go straight there, but thank you very much.
Right. Because under the definition of insolvent, the first event is the contractor has died.
Yes.
Whether solvent or insolvent, on the face of it. So how does that fit in with insolvency?
I can't tell you that. There's no answer that can be given other than that's what is said on the page. But what can be said, my lord, is this is an appeal based on a scenario where the contractor was not a human being.
No, I follow, but the policy, the interpretation of the policy must apply to other circumstances. So what happens if the contractor is an individual and he dies?
And
Solvent.
On that basis, the contract deems him to be insolvent. Right. Perhaps there's a slight artifice in that, I accept, but the contract deems him to be insolvent, and we would say that is. Well, I put my case as I'll shortly elaborate in two different ways, but they all lead to the same conclusion. But on that basis, the insured peril has occurred on the death. My lord, I was going to dwell at 142 very, very briefly to show your lordship, and I'm sure your lordship's already read it, that the definition of insolvency is a wide one, and no one disputes that there was an insolvent event, so to speak, for the purposes of the clause or the cover in this case. My Lord, we then turn to the next little box, when you can claim. And there are two provisions there, both of which are relevant in this appeal. The first is you can only claim under this section up to the date of the Buildmark choice certificate. And let's just very briefly, because this comes in later on in my argument, let's just briefly remind ourselves what that means. It's defined at page 141, my Lord. Fourth definition down, the certificate we issue to the first owner to confirm a home is protected by Buildmark choice. So that'll be a certificate issued to Mr. and Mrs. Smith or Mr. and Mrs. Jones. The second aspect of that...
And that might be years in the future.
It might, well, we know when it is in this case, actually, because it's been pleaded out in the defence. Actually, the certificates were issued on a variety of dates between 2018 and 2020. And we've pleaded that out in the defence. And if your Lordship just wants to, we could just look at that very briefly. Tab 11, and my Lord, it's page, starting at page 103, where in relation, there are, in fact, there were multiple sort of sub-policies, and they all had a little policy number, and there are 88 in total, because as the court may recall, there were 88 units of social housing which were the subject of the cover. And my Lord, to answer your Lordship's question immediately, you'll see plots 1 through to, in fact, for some reason, I think this embraces, in fact, the totality of the plots, including the but you'll see that it is 2019, 18 and 20. That's when the certificates were issued. And it's at that date that the right to claim terminated according to the first sentence.
Does that mean there was a right to claim before the date of the certificate? Or is it a right subject to the Limitation Act to claim before the date of the certificate?
Well, we say it is a right to claim which, if the claim is not made, by the time of the certificate lapses.
But,
you can claim up to the date. Beyond that, the claim stops.
I understand, but is it...
I understand your question.
Is it a permission to claim, if you like, or an agreement that you can claim up to the date of the certificate, or is it something else?
I don't think anyone suggests at the bar that somehow that works in favour of the claimant. That's not been argued in any way, and everyone accepts that the analysis here is simply when did the cause of action accrue, and was the claim form issued within 6 years next after that date. But I will come on to explain why this is of significance. But before I do so, can I just, to fortify and just to explicate a little further that sentence, go to page 126, where we were all previously at. And if your Lordships were to turn to the penultimate paragraph, your Lordships will see it is said we, that is my client, aim to inspect each home at key stages while it's being built. If we're satisfied with the standard of work we see during our inspections, we'll issue a Buildmark confirmation to the contractor when each home is completed. We will also issue a Buildmark choice certificate to you. Now, and that adds a little content to the first sentence at page 134.
So I understand why the Buildmark choice certificate is relevant for the new house owner,
yes,
and his relationship with the NHBC. I'm still a bit baffled as to that sentence at 134. What has the certificate got to do with the relationship between the employer and the NHBC under the policy? Why you can only claim up to the date of a effectively completion certificate, which is relevant for the homeowner?
Well, because the direction of the policy then converts from being directed at or in favour of the claimant in this case, or the person in the position of the claimant in this case, and transmogrifies to being directed to the homeowner who's now moved in and who now has the benefit of the Buildmark choice certificate, which, as your lordship knows, is a right to claim within a period of time starting from the date of the certificate.
Yes. All right. So you say it's effectively showing the direction diverting from the employer, Peabody, to the homeowner, Mr. Smith. Yeah.
Precisely, my lord. And if one goes, if we stick at 134, there's the next sentence, which again has significance for my appeal and indeed my application below. Contact us and tell us if you have lost the amount you've paid to the contractor or the contractor has not completed the homes. And as we'll see, and as your lordships may have seen, Mr. Mitchell at first instance treated that as a mere notification clause, and we have something to say about that, which we'll come on to. My lord, what we will do, again, this is significant to my appeal, and I know your lordships have read it, so I can take this as quickly as I can. Your lordship will see the three obligations or promises that are made by NHBC under the heading what we will do. And then we have finally right hand conditions and limitations. And it may be that your lordships have already seen this, but there are limits as to how much we will pay.
Yeah.
And the relevant limit is 10%. And we see that, my lord, at page 137 of the bundle. Your lordship will see a box headed financial limits.
Yes.
And option 1, the fourth row, down. The most we will pay for all claims under option 1 is 10% of the original contract price. And
yeah.
Now, my lords, that's all I wanted to say about the policy at the moment. I will have more to say about it in due course.
Are you able to explain why, in the box when you can claim, you are required to tell the NHBC if the contractor has not completed the homes, rather than the contractor's gone bust?
My lord, I have no evidence to
No, it's a question of construction.
explicate that, and there is no factual matrix that I can point to explain why the words are in that form rather than in any other form.
If the event insured against was insolvency, one might expect the policy to require notification of that event rather than a different event, namely the contractor hasn't completed the homes.
Well, it's at that moment that your lordship's reference to the death of the contractor may come in, an expansive conception of the concept of insolvency, and instead of saying you must inform us when the contractor has died, or has had administrative receivers appointed over it, or has had so on and so forth, given that all the variants on insolvency, artificial it may be said given the inclusion of the phrase death, as your lordship has alluded to, they all are likely, or indeed possibly inevitably, not in every conceivable circumstance I accept, are likely to be coterminous with the fact that the contractor has not completed the homes. So it is the language, it's fair to say that the language of this policy is not necessarily the language of a commercial insurance policy that we are used to seeing, but it's language that has plainly been devised in order to make it readily explicable to non-lawyers. And nothing wrong with that.
Readily explicable seems a bit of an exaggeration.
Well,
I may say so.
Yeah. Well, it's using the language of, if I can say this without a pejorative overtone, the laity.
Yes.
And as a result, there are some imprecisions that to the Court of Appeal may seem open to question, but one has to construe what is before one. And what I say in answer to your lordship is that what in an endeavour to make things simple to the employer who doesn't necessarily have to run off and seek legal advice, and that's not the intention, that look, has the contractor gone bust? Yes, ergo he hasn't or it hasn't completed the homes. But the critical point here, and this is to some extent a foreshadowing of a submission I'll make, is that the battle line that was drawn is this a mere notification clause? Because that's how my lord below interpreted it. We say plainly not least because it says when you can claim, not when you should notify of a circumstance or words to that effect. Now, my lords, that is the policy.
Oh, sorry, just a minute. I'm not quite following that. If you're saying that when you can claim is the definition of the event insured against, then that would lead to the conclusion, wouldn't it, that the event insured against is that the contractor hasn't completed the home.
Well, that in its purest form, the contractor hasn't completed the home at every scintilla of time until it has completed the home. That I don't advocate as a sensible construction. Read in the whole and read critically by reference to the immediately preceding box, it is, I say, readily explicable as when the insolvency event has occurred, ergo the contractor has not, brackets, and will not, close brackets, complete the home, you can claim. My lords, I'm going to move on now.
Yeah.
Now, I suggest, respectfully, that there are, before coming to the nub of this appeal, and before coming to the question of what was the meaning of box 1 and the relevant words in box 1, that there are 4 overarching generic legal principles that have particular application in the disposition of this appeal. And some of them feed into submissions that I'll make later on. But I'm proposing to make them now, so to speak, in the abstract, so as to frame the submissions that I then make. My lords, principle 1 is the principle that it is or should be, and I say should be because I note a hint of dissent in my learned friend's skeleton argument on this, trite, that when a defendant raises a limitation defence, whether that's by way of a formal pleading or by way of an application to strike out on the grounds that the claim is statute barred, then the burden shifts to the claimant to show that the claim it has brought is in time, i.e. the claimant has at trial, and of course I accept we're not at trial, and one has to modify the proposition to meet the scenario we are in. Ergo, if one goes to trial and the act has been pleaded, then the burden is upon the claimant at trial to prove to the relevant standard that its claim has been brought within 6 years, that being the typical limitation period, next after the accrual of the cause of action. Of course, there are variations on that, section 32, section 14a, but we don't need to trouble ourselves with those variations, albeit the same principle applies, and your lordship particularly may remember that in the context of the AXA appeal that your lordship decided at the end of last year, where, I'm not going to go into it any further, but where there was a question as to whether the claimant had to plead section 32 by way of reply, and so we put it in the bundle. I don't propose to show it to the court. And my lords, because it would appear on a study of my learned friend's skeleton argument that this proposition is not at least wholly endorsed between my learned friend and myself, I was going to show your lordship certain of the authorities that establish that. Authorities that may well be familiar to this court, so I'll take it as quickly as I can.
We've got, you raise a limitation point, but this is procedurally here, and the limitation point you raised was what the judge called the insolvency point. And that failed, the judge said. know you're appealing against that, but that's the position.
Yeah.
So what other limitation defence have you raised other than the insolvency point?
My lord, that question proceeds on the premise that where the Limitation Act is raised, and it's raised in a particular form, then all the claimant need do is rebut that point and say no more. That's not right. What the claimant has to do is actually positively prove whether at trial or in the different circumstances of a summary judgment application, which I accept, that its claim is either on the balance of probabilities brought in time, trial, or arguably brought in time, strikeout, summary judgment. And that requires the claimant to put forward a positive case as to when it says the Limitation Act runs from.
I'm not sure I quite follow that. Let us suppose that a claimant brings a claim and the defendant puts in a defence which says your claim is statute barred because your cause of action arose at the date of insolvency. And the claimant, let us suppose, applies to strike that out because it's wrong as a matter of construction of the policy and succeeds. Where's the limitation defence?
Well, at that stage, the Limitation Act defence, there isn't one.
Right.
There is no defence.
So I don't quite see how this first proposition advances this case where the strikeout or summary judgment was based, so the judge says, on the insolvency point.
Well, of course, we dispute that it was based solely on the insolvency point, and we say that the insolvency point was misunderstood by the judge. But my lord, your lordship's question doesn't actually address how this application proceeded below, because what happened below is that the defendant put in an application, Michael put in an application, founded on a witness statement which was in the terms that it was pitched, saying that the limitation, the cause of action accrued on the date of the insolvency. The claimant, in response, responded by saying, both in evidence and by way of submission, not that's just wrong, but saying no, the Limitation Act, the cause of action in this case accrued, and this is a positive case that it advanced before the court below, and advances, I should say, before this court, a positive case put in various ways, but having one central common thread, which bound each of the variants together, that no, the cause of action accrued in this case when the claimant had expended, at the very least, £1 more than the amount of the vantage contract. We need to be very clear about this, my lord. The position of Mr. London in his witness statement was, in essence, and shorn of the complexities, and there were various complexities and various variations on the theme, but the theme was simply this. Looking at the first sentence, the first box of option 1, and looking at those critical words, the words have to pay more to complete the buildings because the contractor is insolvent means has had to and has indeed paid at the least £1 more than the contract sum. Now, when I say there are variants, and I don't want to be in any way to simplify my learned friend's case, the variants were, well, in fact, it might not be precisely that. It could be when the final certificates have all been put in and paid, which of course would be a much later date than the £1 more position. That was stated with great clarity by the claimant as its case on limitation below. It's pleaded it, as we'll come on to see, with clarity, albeit the working out of it gives rise to, and we don't need to get into I'm not interested in the facts. I'm interested in the principle that the claimant adheres to say that its case is brought in time. And it's very clear, and this is the central point for this court. Does those words in the first box of option 1, and those words have to pay more, mean has in fact paid more than the amount of the vantage contract? And just to give that a bit more flesh, his lordship below used a vivid phrase. He said, as at the date of the insolvency, the vantage contract was, forgetting about the precise pounds, shillings and pence, the total contract price was 10.3 million. Of that 10.3 million, 1.5 had already been expended by Peabody's predecessor, Catalyst, and paid over to Vantage. So the phrase he used, you may remember it, was, therefore there was £8.8 million in the tank. And essentially what he appears to have endorsed, although he declined to arrive at a final conclusion, albeit this was the case that was very clearly put by Mr. London and by my own friend, putting aside the precise day of the week or the date in 2020 or 2021 when that event arose, which is irrelevant to my purposes. What he said and what the claimants, what he appears to have said and what the claimants certainly argued was that it's only when Catalyst had paid 8.8 million plus £1 to the new contractor, or the new contractors, because there wasn't a single contractor appointed, that brought into life the cause of action and the right to claim under option 1. Now, I say there were variations, and we'll look at those variations. I don't want to skate over the way it's pleaded, but that's the central proposition. And essentially, in one sense, the central proposition for this court to decide, which it can and should decide, in my respectful submission, is whether that is the correct construction. And it's a question of construction, not fact, of those words. And that's a very important question, given that this contract and this form is very commonly and widely used. My lords, let me very briefly show your lordships the learning on this burden point. I hope I can do it in 3 minutes. If your lordships were to pick up the authorities bundle and go to tab 4. Cartlidge and Jopling, of course, an extremely well-known case. I won't go through the facts of it in any shape or form. But if we go to page 26 of the external pagination, your lordships will recall that was the question of when the personal injury had actually occurred and whether the cause of action accrued on the date of the injury, on the date of the poor plaintiff's learning of their injury. And of course, your lordships will remember that this case gave rise to certain legislative changes because of the harshness of the result, acknowledged by the courts deciding it, it's fair to say. If we go to page 26 external, to Lord Justice Harman's judgment, and we see at the bottom 6 lines, as to South's case, there was a difference of opinion, there being no film in his case before 1952, when the signs were visible of the disease in an early stage. And then this is the important sentence, where, however, the defendant raises the statute of limitations, it is, I think, for the plaintiff to show that he is not within it, and for the defendant to prove, and not for the defendant to prove the opposite. Lord Justice Pearson had something to say about the same question at page 32 external. Last paragraph of page 32, where there is a joinder of issue on a defendant's plea of the statute of limitations, as there has been, because A, there was a joinder by way of evidence and argument below, and now that's formalised into a plea in the reply. The burden of proof is on the plaintiff to show that his cause of action accrued within the 6 years, or whatever is the relevant period, and then a number of old authorities are then cited.
Do we get all that in London Congregational Union and Harris?
My lord is ahead of me, as ever. We do, and for that's tab 6, page 78 of the external pagination, and your lordships no doubt knew it anyway. The point, the matter is very clearly stated in the judgment of, I think it's Lord Justice Ralph Gibson. And we've cited another more recent decision at tab 12. I don't think I need to take your lordship to the decision of Judge Havelock Allen, Queen's Counsel, and then Mr. McGee at tab 25 sets out the law, which again I won't trouble the court with because it's well known to the court. But well, that's my principle one. And it actually, in practice, this is what happened. The claimant came along and said, no, the cause of action accrued on this date, and we're within time. And that's what the claimant has now done by way of reply, as we'll come on to see. My lord, the second principle of broad law, which we say should inform and frame the argument and the disposition of this appeal, is that it is the policy of the law generally to accelerate rather than to retard the accrual of causes of action.
Yeah.
And my lord, I hope your lordship will forgive me for putting in our bundle of authorities the decision in Batley and Faulkner, a case that I always feel puts the matter with, if I may say so, and as one would expect. Given
We've got it in the Edmund Erdman case as well.
We have it. My lord, yes, sometimes oral advocacy seems unnecessary before your lordship.
Just give me the tab numbers. My lord has a mental filofax with which I'm not blessed.
I have experienced that on many occasions.
So just give me the tab numbers. That's all I ask.
Tab 3, my lord, and this is an old case and none the worse for that. And there are decisions of four of their lordships, the Chief Justice, and for this purpose, I take your lordship to Mr. Justice Best's decision at page 12 of the external pagination. Those wonderfully pithy judgments of that period, where, with the facts of this case don't matter, but if we go to the last 10 lines of Mr. Justice Best's decision, bottom of the page, the object of the statute of limitations was to prevent persons from being charged with claims who, in consequence of the lapse of time, might have no means of proving a discharge. If a person is served with a writ, he knows it is necessary to preserve the evidence, therefore he's on his guard. If therefore there is no legal proceeding against him, he imagines there's no cause of complaint. If a long period of time elapse, his witnesses may die, and he may be, and so on, and so on. The general tenor of that case is quite clearly that it is contrary to policy to allow old claims to drag on, and that the policy of the law should be to require plaintiffs and now claimants to bring their claim as soon as possible. But as my lord has said, there is a more modern statement of that principle in the Nycredit decision, tab 10, my lord, of the authorities bundle, and in particular Lord Nichols's dictum at page 163 internal, which is 1633, I should say, which is 152 external, where at the red lining we see the decision of the House of Lords further within the bounds of sense and reasonableness. The policy of the law should be to advance rather than retard the accrual of a cause of action. And in this case, we say that has particular application because, as I will come on to seek to demonstrate, the outcome, if my learned friend is right, is that there were many years post the insolvency when the claimant was expending monies in clearing off trespassers, in finding new contractors, in entering into a management contract in early 2017, and then entering into multiple contracts with various contractors. There was no main contract. If that is right, if my learned friend's case, that is right, then throughout those 3 long years, well, my learned friend would say 4 or 5 long years between the insolvency in June 16 and either a date in mid-2020 or, on his more extreme case, a date in 2021, there was literally no cause of action and no right to seek any form of recompense or indemnity from the defendant. And that should be a matter that weighs with this court, in my respectful submission. That is the inevitable and overt outcome of my learned friend being correct, that throughout that period, why were they communicating with my client, one asks, when they had no cause of action against it? That's principle 2. My Lord,
You would accept, I suppose, that it always depends on the circumstances. In this case, the policy, other statutory provisions. I mean, the Building Safety Act, rather than accelerating, now gives you a cause of action going back to, a generation.
quite. Your Lordship's had court to, I know your Lordship's had court to consider that.
I have. I mean, it's an astonishing, on one view, an astonishing provision designed to try and secure justice. I completely understand that. But that might be said to be the contrary to advancing rather than retarding.
Or, well, it's expanding.
Yeah.
I mean, I can't pretend to be able to give your Lordship a complete answer to a very complicated question, which your Lordship is, of course, a master of. But I don't see that point has any bearing on the particular point that I am
It's
seeking
just
to...
that I understand your general submission. All I'm saying is it ultimately it depends.
Oh, I quite accept if the words of the statute or the contract are explicit, then principle must yield to particularity. That I concede. The third principle, my Lord, which again has the same attribute, is that it's connected to principle 2, but is distinct. And that is that it will normally require clear words before a contract will be construed as giving a claimant control over when time starts running against it. My Lord, for that proposition, we can turn to the decision of the Court of Appeal at tab 14 in Legal Services Commissioner of Henfield. The facts, again, are very far removed from this case relating to a claim by the Legal Service Commission against a barrister who'd received legal aid monies on account. There was an attempt to reclaim those. But we need only go to paragraph 31 at external page 228, where the Master Rolls said this: save where it is the essence of the arrangement between the parties that a sum is not payable until demanded, e.g. a loan expressly implied repayable on demand, it appears to me that clear words would normally be required before a contract should be held to give a potential or actual creditor complete control over when time starts running against him, as it is such an unlikely arrangement for an actual or potential debtor to have agreed. Now, what's the relevance of that to this case? It is of great relevance indeed, and that is because it is the claimant's case that it is master of when it, on the insolvency of the original contractor, enters into a fresh contract with a new contractor or series of contractors, and therefore it is the master of when, on its case, it has spent further monies to use up the tank. The money is in the tank, to use the phrase of the judge below, and paid the extra £1 more. So it is absolutely, and I think it is accepted by the claimant, that its case requires this court to construe the relevant insuring provision as meaning that it has total control over when the cause of action accrues, because it is only when, on its case, it has spent, in fact, £1 more, or indeed it could be a much later date than that on one of its variations, that the cause of action accrues. My Lord, the fourth principle, which is a principle which I can spend very little time on indeed, is that, because it's trite of course, is that time in contract runs not from loss, but from date of breach, and the knowledge of the claimant that it has suffered a loss or that there has been a breach is entirely irrelevant. And again, if I can be forgiven for going back to the old case of Batley and Falconer, tab 3 of the Lordship's Authorities bundle, and in particular to Chief Justice Abbott's decision, we can see in the red tabs or the red underlined sidelined words at page 11 of the external pagination some lapidary statements by the Chief Justice it would be 2/3 of the way down his judgment, extremely dangerous to inquire in every particular case the precise period of time when the damage first came to the knowledge of the plaintiff, and so on and so forth. And indeed, let's not exclude Mr. Justice Bailey.
But that was really the point in Cartledge and Joplin, wasn't it? They didn't know that they had a cause of action, but they had.
Quite. And then if we go to the red...
Pirelli.
And Pirelli.
And Pirelli. And Pirelli.
Which remains good law. Who knew?
Yes, well, quite. And of course, the Supreme Court, and indeed my Lord in the Court of Appeal, have spent a good deal of time, I believe, considering that.
Well, I was bound by it, but they weren't, because there were 7 of them, but they still didn't overrule it.
No. My Lord, if I can just, again, this may not be anything new to this court, but if we looked at Mr. Justice Bailey, in the red sidebar, one of the objects of the statute of limitations that action should be brought to trial in a period of time when the defendant can be prepared with his witnesses. That would not be the case if the action might be postponed to an indefinite period. Now, it is absolutely at the centre of my learned friend's case that his client can postpone the accrual of the cause of action to an indefinite period. And we will see how he responds to that point in his skeleton argument in due course. My lords, those are the 4 overarching principles of law that I suggest should guide this court's disposition of this appeal. With that, I wish to now spend at most 7 minutes on the facts of this case, because they frame the question of when the cause of action accrued in real time. My lords probably have at least seen the majority of these, but let me, if I may, put a bit of flesh on the bone, so to speak. Fact 1, Catalyst enters into a contract of a construction contract with Vantage for the construction of 175 dwellings on the 20th of November 2015. Your lordships will have seen that the total contract sum was some 23.8 million, and that there was an express division between the sum attributable to the private dwellings, which were not insured, and the sum attributable to the social housing units, which were insured. And on that, for that attribution, I would ask your lordships to note, I do not go to it, page 32 of the supplemental bundle, where that attribution of the 10.3 million is made clear out of the overall 23.8. The policy of insurance, my lord, was entered into on the 2nd of March of 2016. For your lordship's note, page 49 and 50 of the supplemental bundle. I do not go to that. Vantage ceased work on the 17th of June. That is common, well, that's the claimant's case rather, and for the purposes of this appeal, therefore common ground. And for your lordship's note, that is asserted in the particulars of claim, paragraph 15, page 76 of the core bundle. It became insolvent on the 29th of June as a result of the appointment of administrators. For your lordship's note, page 120 of the supplemental bundle shows the appointment. My lord, we're now getting into the critical zone, so to speak. Remembering always the date of the issue of the claim form, 24th of July, 23. In autumn of 16, Vantage have disappeared. There are squatters on site, and Catalyst has to spend significant sums clearing them off. The sum is in excess of £56,000. That is their case, and we will come on under ground 5 to spend a little more time showing your lordships precisely how it's put. But for the purposes of your lordship's note now, that is the case of the claimant. Paragraph 17, particulars of claim. On the 7th of December 2016, Catalyst notifies NHBC, my client, that it intended, quotes, to claim via the insolvency cover for additional costs in relation to the first registered units. My lord, it's now appropriate. We can put away the bundle of authorities and pick up the supplemental bundle, if that would be convenient, so that we can look at a couple of the documents that are in issue now. For this purpose, tab 9, page 267, please. And we are now 7 months or so, 8 months before the critical 6-year date. And here we have Catalyst writing to my client at the bottom of page 267. Further to our meeting last week, I'm attaching a copy of the organisational chart. We've for our construction management consultant on the Stanbridge project, i.e. our project. They are Stack, we'll come on to Stack, and I've worked on this on another one. Works on this 175 unit estate started early 16. Contractor went into administration in June with only 3.5 out of the 2.24 million contract completed. My lord, just pausing there, that's the full sum. What is common ground for this appeal is that as regards the amount attributable to the insured units, it was 1.5 million out of 10.3 million used up or spent. Hence the 8.8 in the tank, as the judge below put it. I'm using round numbers because it doesn't matter what the actual precise one is. And then my lords can see over the page what is then said. And fourth bullet point, Catalyst intend to claim via the insolvency cover. And the question is posed. That's December.
So that was you said there was a notification of the claim. That's the notification of the claim?
Whether it's a notification or not, in a formal sense, I don't, it doesn't matter to my purposes. I'm just simply giving your lordships now the real-time events that were occurring in the period before the relevant 6-year date, which occurred on the 25th of July 17. If the cause of action accrues before that date, this case is out of time. Now, what then happens, my lords, is that the claimant predecessor enters into a contract, a management contract, with a company referred to in this email called Stack London, and the overall fee of Stack to manage the various contracts that are going to be entered into by the claimant with the various contractors. Well, they've decided not to bother with the main contractor. We can see at page 244, same bundle.
244.
Yes, my lord. Well, the contract itself is elsewhere. We don't need to look at the contract, but this is the schedule of amendments to that contract. It's a construction management appointment, and that means, as I hardly need tell this court, a contract whereby Stack weren't actually doing the building, they were managing the building work, and the sum that was payable to Stack was the construction management fee just below the first hole punch, 1.04 million as adjusted where applicable, the lump sum. That's the construction, the fee they had to pay Stack by entering into this contract on the 18th of January 17. And that contract had with it a forecast final cost for the totality of the construction of both the insured and the non-insured properties of £25.6 million. We see that, my lords, at page 243, and that requires a certain amount of squinting. If your lordships were to turn to the right at the bottom of the final yellow column, which is headed Stack Forecast Final Cost, a figure of 26.644 million. And just to explain what that is, that was Stack's estimate of how much it would cost Catalyst to build out the works that had been left in their incomplete state by Vantage, who are now, of course, out of the picture. And the same number we see more clearly stated at page 245, which is another aspect of the schedule of amendments to that contract. 245, target cost, second hole punch, the sum of 25 million as set out in the project cost plan appended to Schedule 13, which is the document I've just shown your lordship. So at that time, it was estimated by Stack that it would cost Catalyst, ergo Peabody for these purposes, 25 million as at that moment, and therefore they were going to be spending, if that estimate was correct, considerably more monies than they would have had to spend with Vantage, absent Vantage's insolvency. And to be clear, what that was for completion of the, and well, let me go to it, it's page 57, what the actual target cost embraced, we go to page 57 of the same bundle, tab 7. That sets out in the first recital, handwritten, completion of the design, construction, and defects rectification. I.e., Vantage have left. They've left the property in whatever state the development was in. Stack have come in. They're going to be paid a substantial sum of money to manage the contracts going forward. A whole bunch of contracts are going to be let out to various contractors, and that's the works that are encompassed by the 25.6 million, which is, of course, very considerably more than what Vantage would have charged under its contract.
So presumably the trade contracts are going to be entered into by Stack.
No. I believe the way it was planned to work and did work in practice was that Catalyst itself entered into a whole bunch of contracts managed by. Is that right?
Yeah.
My learned junior, who's a.
Third recital, yeah, you're right, comprises work to be carried out in contracts between the employer and contractors.
Yeah.
Yeah, okay, thank you.
My lord, the next relevant fact is 264 of the same bundle. We are back to tab 9. And an email which your lordship should, in my respectful submission, spend a little time noting. This is now February 17, so we're now still 5 months away from the critical date, July the 25th, 17. This is Catalyst again to my client. As you are aware, Vantage went into administration, employed on a design and build contract, and I had 107 units on the first phase of a total of 175 registered. My lord, the 107, I think there was some of the additional 88 to 107, they were registered on some different scheme, about which there's no evidence, but it doesn't matter. We are proceeding as discussed, using a construction management contract with Stack. We've seen that. Based on the Stack figure, using the gross area and the area of the 107 insured units within which the 88 were included, and then see that number. 107 based on Stack is 14.3 million. 107 based on Vantage was 12.9. And so that critical paragraph at the end of page 265. A positive and clear assertion by the insured, viz. Catalyst, that they have a claim under the policy against my client, which will lead to a figure of 1.358, more than the maximum 10% claim. And I've shown your lordship where that 10% comes in, plus a whole bunch of other fees. And your lordships should just bear in mind, it is the claimant's case that at that stage, it had literally no rights of action of any sort against my client. And the only way, to be very clear, that it can make good that proposition is if it's case that the relevant words of the policy, which I've shown your lordships, mean that the claimant, in order to claim, and the insured event is the actual fact of expenditure of 8.8 million plus £1. Before it spent 8.8 plus £1, no claim, no right of indemnity, nothing.
If somebody goes insolvent or commits fraud, and you have no idea whether you're going to have to pay any more, your case is that you have to start proceedings not knowing whether you will have to pay more, because you need to ensure that you bring it within the relevant limitation period.
Well, you don't have to start proceedings on that day. You've got 6 long years in which to bring the claim.
Well, yes, but what happens if things are being unravelled? I mean, your case is that you have no idea, even though you have no idea whether you have to pay more, your cause of action accrues.
It is, and I will explain precisely why that is the case when I come on to look at some of the authorities. It is. But remember, it's not an obligation to issue the claim on the day of the. You've got a 6-year window to do it.
Yeah, but
And that is we'll come on to that. My lord, a claim was actually notified in August 2017, and we can put away the supplemental bundle now and turn to the core bundle, and that is the claimant's own case. This is particulars of claim, tab 10 core bundle, page 81. Para 27. Following Catalyst's notification of its claim to NHBC in around August 2017, and the date appears to be the 3rd of August, but it doesn't matter. NHBC appointed a quantity surveyor to act on its behalf. Now, that's an interesting fact, because on the claimant's case now, it had no right to notify a claim. In fact, that right didn't accrue for another 3 years or possibly 4 years thereafter. My lord, the letter before claim was sent on the 17th of November, and then there was correspondence, which I won't go into.
17th of November.
22, sorry, that was my error.
No.
17th of November 22. For your lordship's note, that's page 125 of the supplemental bundle, which in view of the time, I don't go to. My lords, I then said that those are the stark facts which should inform the outcome of this appeal. The next question and issue that I turn to is the pleadings.
Is what?
The pleadings.
Pleadings.
Now, your lordship's already got, I think, the claim form and the particulars of claim open. We can look very briefly at the claim form to see how, because there was a preemptive plea as regards limitation. Page 72, external pagination. Headed continuation sheet. Per the certificate, the policies included contractor insolvency cover, viz. The cover set out at option 1 we've looked at, against the risk that Catalyst would have to pay more to complete the building of the units because Vantage is insolvent. In the event Catalyst has had to pay more to complete the units because Vantage became insolvent, and then there's some explication of that. And then we have the denial that the claim is time-barred preemptively in the last paragraph. And there are 2 ways it's being put. The alternative way, an estoppel is now no longer pursued. So the primary way did not start to run at the date on which it went into rotation, but on the date on which Catalyst had to pay more for the units to be completed, which of course begs the question, what is the legal analysis that applies to the question of had to pay more? What does it mean as a phrase? As a phrase in the policy, not as an event in life, because we're not here to debate facts. We're here to debate what that phrase means. If it means that it's the date when they've paid at the earliest £1 more, then my appeal fails. Let's be very clear about that. If that's what your lordships decide, then my appeal fails. If it doesn't mean that, then my appeal succeeds. It is as binary as that. My lords, let's carry on with the particulars of claim.
Let me just understand that, because the construction issue, which is the first issue, is insolvency plays had to pay more, and that was the issue that the judge decided, and he decided it's had to pay more. But the judge hasn't decided, has he, that if it's that latter construction, that the claim is definitely not statute barred?
He has decided that he won't decide the question of the meaning of the phrase had to pay more, notwithstanding a construction for that phrase was offered by the claimant below and has now been pleaded.
I'm just working it through. So that's the first issue. If it's that if the respondent's construction is correct, the limitation point is, as it were, to use the expression, still up for grabs.
On the facts it is, because it may be said that...
So the point about, for example, the point you make about the forecast cost in February 2017 is open to you. If that's the right construction, you can say, well, that's when the cause of action accrued.
Well, my lord, to be very, very clear, my case before this court is simply this. The cause of action accrues on the date of the insolvency. That is the insured peril. But if that's wrong, the cause of action still accrued on the insolvency because, as a matter of fact and reality, in fact, on the claimant's case, as I'll come on to show, the insolvency led to the claimant having to pay more. As a matter of objective fact, there's common ground, that is, as I'll come on to demonstrate. The only way the claimant can get itself in time is if it can establish, and it's a matter of pure law and construction before this court, if it can establish that the phrase "had to pay more" means has in fact paid £1 more at the least, and very possibly, so they say, a lot more than £1 more because they have a final certificate case as well. That is the central question.
I wonder about that, Mr. Grant, because of the way in which this application came before the court.
Well, my lord, it was
I'm talking procedurally.
The case that was put at first instance by me was that the cause of action accrued as a result of the insolvency simplicity.
That was the question for the judge to decide.
No, well, I argued a wider point, as in the skeleton argument, that on that date, as a matter of objective fact, the claimant had to pay more. Not had paid more. Of course, if the contract means that you actually have to spend the 8.8 million plus £1, then my appeal fails. Of course it does. But if it doesn't mean that, then my appeal succeeds, because there's no other case pleaded, as we'll come on to see, by the claimant to in respect of limitation. The claimant's case, as I'm going to come, can I come back to this in 3 minutes when we've seen the way the case is pleaded by the claimant? My lord, so this is the particular claim start at page 73. And setting out the facts as pleaded, which we don't in any way suggest your lordship should go behind for this appeal, although they are controverted on the defence, but for the purpose of the appeal they are to be treated as correct. The notification is pleaded at paragraph 27. Paragraph 28 sets out the communications that occurred over a period of time, and the particularisation of the claim, how it was arrived at. Paragraph 28, how it's built up, the 918,000. And then the only other paragraph I need to show this court is para 52, page 87. In the event Catalyst has had to pay more to complete the units because Vantage became insolvent. So it is its own case that as a result of the insolvency, it had to pay more. It will succeed on this appeal if it can persuade your lordships that the relevant phrase in the policy of insurance requires that it actually has paid more. My lords, let's go straight to the defence. The limitation plea is taken at paragraphs 2, page 91 and 92, tab 11. Peabody's cause of action accrued, this is little 1 at the top of page 92. If any, accrued on the 29th of June, when Vantage became insolvent and Catalyst consequently had to pay more to complete the insured homes. And then some alternative pleas at paragraph 2. And then then subparagraph 3, the general plea that on any view it was issued out of time. Now, We need to look now at the reply, which postdates the judgment. Now, we can start at paragraph 5, page 114. There's an estoppel pleaded there, founded on Mr. Mitchell his judgment being the only judgment, which was a perfectly fair, well, it's not right, but of course at the time there was no appeal judgment, or appeal hearing listed or whatever. Then 6. This is where it's stated very clearly. It is denied that Peabody's cause of action accrued on the dates referred to in the relevant paragraphs of the defence. Catalyst did not have to pay more to complete the homes on those dates. And then it sets out why on the 7th of December it didn't have to pay more because it had no obligation, there was no obligation on the part of Catalyst to pay more to complete the homes. Last 2 lines of 6.1. So that's its response to the 7th of December. There's a common theme we'll come on to see. 6.2, they deal with the date of the 18th of January being the stack contract date. And if we go straight to 6.2.6, page 115, again, the common theme is the actual sum paid or not paid. 6.3, 10th of February, that email I invited the court to consider quite carefully. That's not relevant, says my learned friends. Last 2 lines, that was simply an estimate. It does not evidence an obligation on the part of Catalyst to pay more to complete the homes. So it's actual, it appears to be at the moment, legal obligation. Actually entering into a contract, or a series of contracts, which collectively amount to 8.8 plus £1. And then para 7, which is the critical paragraph, where a positive case is pleaded as to when the cause of action accrued. It accrued on the first analysis at the point of time during the works when the cumulative costs incurred by Catalyst pursuant to the building contract and the various other mechanisms for payment exceeded the original contract price under the building contract. Now, the reason why the building contract, which is the Vantage contract, is included there is because, of course, the 1.5 billion paid is part of the equation. So you have to get to the stage when Catalyst had paid £1 more than the original building contract sum, 10.3 million or so. That's the moment when the cause of action accrues. An alternative, 7.2, is a variant on that theme that still carries with it the common proposition of actual payment in excess of the contract price under the original Vantage contract. When the cumulative costs, I'm quoting at 7.2, incurred by Catalyst pursuant to the various things, building contract, the stack contract, and now it's interim contracts, exceeded the original sum. And then a further alternative is a kind of running a sort of counterfactual has to be entered into against hypothetical costs which would have been incurred with Vantage against costs actually incurred. But again, the central proposition is actual payment in excess of the sum payable to Vantage. That is the case.
I mean, you're going to have some sort of hypothetical counterfactual, aren't you, to work out the extra cost? That's a hypothetical counterfactual because that requires, it involves a lot of elaboration, and the judge below said it would have to require expert evidence to work out when the cause of action, if that variant were eventually plumped for, that requires the court on a sort of day-by-day basis to work out how much was being paid would have been paid to Vantage on a sort of day-by-day or month-by-month basis. So even on your case, you need some kind of hypothetical, don't you?
No, on our case.
You stand at the moment of insolvency, as I don't know if I've understood your case correctly, and you say, what would it have cost to complete these buildings if Vantage had gone on, which it hasn't, because it's bust, and what would be the reasonable cost, the reasonable extra cost of completing the buildings?
No, that's not right in my respectful submission. You've got the Vantage, the amount payable to Vantage is a fixed sum. We know what it is. It's the contract, and on the date of insolvency, the claimant knows how much it's already paid and how much was left to be paid to Vantage.
Yes.
That's a fixed sum. What what on our case, which is a matter of daily occurrence, is on our case, objectively speaking, on the date of insolvency, how much would it cost
To get somebody else.
to get someone else in?
Yeah.
That's a matter of evaluative judgment, I quite accept, but it's a matter which it's the meat and drink of quantity surveyors' activities across the country. But that is the case which your lordships either accept or don't accept as correct, as pleaded at paragraph 7 of the reply. Now, it seems to be the underlying theme here, putting aside the various possibilities of variation about whether it's interim certificates or final certificates that are relevant. One can see one possible variant which is more of a conceptual variant than a factual variant, and that is whether the meaning that the claimants, adhere to is legal liability to pay or actual fact of paying. But that doesn't really matter for these purposes because it still requires, on the claimant's case, for the claimant, it being master of this question, to decide to enter into a bunch of contracts whereby it has a legal obligation to pay to third-party contractors a sum which is at the least, so it would appear, £1 more than the sum that is left in the tank, to use the judge's phrase. Now, we might just briefly see how this was put in evidence at first instance. Mr. London's witness statement, supplemental bundle tab 8, where it's a long and involved witness statement. And for the purposes of the appeal and the application below, I didn't dispute factually any of it. What I did seek to do was address the actual underlying conceptual premise of the evidence. It starts at page 162 of the bundle. We can turn straight to paragraph 17. There's a lot of complexity here.
The curious thing about this was that at the time it was put in, the point was a matter of pure construction.
Well, what Mr.
I mean,
yes. What Mr. London
had
was,
I been the
sorry.
judge at first instance, I might grumpily have said, this is all inadmissible. Any evidence is inadmissible, it's just about what the contract means.
Well,
I'm sure I wouldn't have been grumpy and wouldn't have said that, but I might have thought.
But except that the claimant can no doubt correctly conceived that it had a duty to actually explain, at least to the relevant standard at an interlocutory stage, that it had a coherent, legally coherent case as to why its claim had been brought in time. And I repeat again, nothing that I say today involves your lordships having to make any controversial findings of fact. But what is clear is that the conceptual underpinning of this witness statement is that the claimant's case is in conformity with the reply as subsequently served, that the date for accrual of the cause of action is the point in time, the moment in time when Peabody has paid, or Catalyst has paid, £1 more than the Vantage contract. We see that at paragraph 17, when he says at line 3, I address when Peabody incurred additional costs of completing the homes. He then sets out all sorts of elaborations on how to go about that task, deductive task, or looking forwards, and then there's the third hypothetical analysis, which I think is embraced by paragraph 7.3 of the reply, which Mr. London himself classifies as a mammoth task, pre-penultimate sentence line of paragraph 17. So that's the paragraph 17 is the introduction. But let's see how it pans out in practice. Paragraph 20, and there's all sorts of numbers being thrown around here, which we don't need to worry about. 20, the date when Peabody incurred more than it would have done with Vantage is relevant to the accrual of a cause of action which can be calculated. He then sets out how much had been paid already to Vantage, the 1.5, 1.484 as it happens, on his case, which I don't contradict for these purposes. There was therefore 8.8 left. Your Lordship will remember those words that I've used. It was, and then this. It's as clear as it can possibly be. It was only when that sum of 8.8 had been paid on account of the project that Peabody began to have to pay more to complete the project than it would otherwise have done. Para 20. Para 21 continues the same theme. If we go halfway down the page, just below the first hole punch, it would not be known whether the cumulative cost of the works would have exceeded the Vantage contract price until the sums were well underway. When I say it's as clear as possible, the analytical conception behind this witness statement is clear. The actual working out of the facts is anything but clear. And we can see that well, let's go to paragraph 24, where, again, it's clear what the claimants are driving at. Last sentence. For the purpose of disposal of this summary judgment application, I make the factual observation derived from these documents. And this is after a whole very complicated analysis of various accounts with various contractors, including muckaway and piling and so on, at page 170 and 171. He then says, well, from all this analysis, it's clear that final accounts for at least 6.3 million of the works were not agreed until July 2020 or later. That's said to be relevant to limitation. And then 25, where he sets out all his calculations to show that by the end of July 2017, being the relevant time for the limitation purposes, the claimants had on his evidence not spent the full 8.8 plus £1. Ergo,
where are we?
25E, my lord. Sorry, I'm going quick.
Thank you.
This is, if we go 4 lines down at E, this is because that would mean that by 2017, the sums which had been incurred were 1.48 plus a whole bunch of other figures, ergo only 5 million, ergo less than 8.8, ergo no cause of action. And therefore we see that put into practice, the last sentence. Therefore, on any account 6 years before the claim form, the insured had not got close to spending more than the contract sum. And then 28, finally, then I'll leave this subject. 28, he says that, in fact, the precise date when £1 more had been spent is complicated, because it sort of, on one view, it could have been the 25th of March 2020, but then there were some deductions which brought it back down again, and it sort of hovered back and forth until finally, on the 29th of September, it became clear that it had spent £1 more than the 8.8 left in the tank. And there's a bizarre table which is attached to Mr. London's witness statement, which I asked the Lordship to look at, page 226, where essentially this is apparently how the cause of action accrues on this policy. We see the date of insolvency at the beginning, and then the blue line of expenditure going up and then going down a bit and going up and up. And then we see the red line is the full contract sum of 10.3. That's a constant. And it's only when the blue line goes above the red, apparently the cause of action accrues. But then it disaccrues. And we have a sort of Schrodinger's cat situation where, yes, the cause of action pops into existence in March, but then it disappears again because of some deductions. It then goes back into the black or the red, however you want to put it. But then back into April and May, it disappears again.
Well,
my lord,
right?
Is
that right? I mean, it assume that this table is accurate.
Well, I do for these purposes.
The cause of action would accrue when the blue line crosses the red. What happens thereafter goes to the quantum of the loss.
Well, not according to Mr. London. It may not matter a deal, because Mr. London settles on June as being the sort of halfway date between March, when the blue goes above the red, and September, when it definitively goes above.
Once your cause of action accrues, it doesn't disaccrue. You may not suffer a loss, but
I'm just following through the logic of Mr. London's evidence. But the critical point here, my lord, is that I say it cannot be right. So I'm going to go on to supplement.
Well, I follow that.
To have a cause of action that has to be...
It's all too woolly and complicated, therefore my interpretation must be correct.
Well,
basically what he it comes to.
Well, I'm going to come on to now give 6 brief reasons why the analysis of the claimant is wrong and my analysis is right. The first brief reason is that the phrase in the relevant contract is not has actually paid more, it is have to pay more. That is an objective question. It is a forward-looking question, not a backward-looking question. It is a question not dependent on knowledge or the ability to state precisely how much your claim is. It is a question that arises for objectively at the moment, in this case, as we know, when the insolvency occurred. And my lord, just to digress for a second, my lord below said, well, what about the situation where there's just a receiver appointed and the contractor carries on? And therefore there's no, it just carries on and he builds it out in the normal way. Well, that's not this case. This case is a case where there was an insolvency which on the claimant's pleaded case led to the claimant having to pay.
We're trying to interpret the policy.
Yes.
So do you say that have to pay more? Does that connote some sort of legal obligation to pay more?
No, it doesn't.
And if it doesn't, what does have to mean?
Have to pay more means objectively, as a result of the insolvency. Well, I should say I have a prior point. My prior proposition is simply the insured peril is the insolvency. If I'm wrong on that, and the insured peril is the insolvency plus the having to pay more, then that is not a legal obligation to pay more or an actual fact of paying more. Right. It is an objective question. Does the insolvency mean that this claimant have to pay more? Now, the fact that
So just pause a moment. So if I want to build a housing estate, the contractor goes bust, and I say, oh well, all right, I'll give up now. I won't do any more. Do I have to pay more? I'll just abandon the whole thing.
In order to complete the works, you have to pay more. The fact that you abandon the whole thing is not relevant to the policy. The policy responds to the objective question of whether, on my subsidiary, my primary case is that the insured peril is the insolvency.
Yeah,
and on my subsidiary, that the obligation to pay more is the objective question which asks itself, the fact that it requires to be answered to an actual particularity requires time and effort is irrelevant, as I'll come on to show from the authorities, is an objective question. If, objectively speaking, in order to build out the development, as a result of the insolvency, you have to pay more, then a cause of action accrues on my subsidiary position. And
so have to pay more means if it will cost you more.
Yes, objectively speaking. And my lord, I draw, if I can tread softly here, because I'm conscious that I'm quoting my Lord Justice Coulson, who knows the case far better than I ever will, that Lord Justice Coulson, in not an exactly analogous case, but a case which involved an insurance policy insuring against reasonable extra costs, and where it was submitted to the court, of which he was part of the Constitution, his lordship was part of the Constitution, that reasonable extra costs meant actual expenditure, his lordship said no. It means it's an objective question of what it will reasonably cost, and it does not require, in order for the policy to respond, for you as the insured to actually spend the money. That's Mancicolapti, Authorities Bundle tab 16, at paragraphs 83 onwards. I don't have time to take my lords to that, but I hope that is a fair précis of what his lordship decided in that case. If we turn to my learned friend's skeleton argument now, Core Bundle tab 17, my learned friend is very clear about this. Paragraphs 42 and 43, page 362 and 363 of the external pagination. He is very clear that the policy only responds if there actually has, in fact, been payment by the insured in the relevant amount. There are variations on what that amount may be, but that's the common theme, 42 and 43. And it would appear from paragraph 59 of the judge's decision below that he also agreed with that. And we say, with respect, although he purported not to decide the point, if we go to paragraph 59 of his judgment, it would appear that the judge himself agreed that there was some, for the policy to respond, there needed to be, this is page 58 of the bundle, core bundle, there had to be extra, the costs had to be expended. So, well, that's my first point. And before leaving it, and perhaps in answer to a question posed by my Lord Justice Moylan, and if we just go back to, because my learned friend takes the same point essentially. If we go to paragraph 36 of my learned friend's skeleton argument, page 361 of the bundle, tab 17, in fortifying the proposition to 42 and 43, my learned friend says, NHBC's approach renders the quantification of the indemnity a matter of prognostication. Para 36, this is, when the actual loss suffered will crystallise in due course in any event. So what my learned friend is saying is, look, the cause of action should only accrue when the insured knows precisely how much more he's had to pay. And that requires him actually paying it out. And it's only once he's paid it out that he has a cause of action. Now, my lord, that point is just wrong as a matter of law with respect, and involves us just picking back up the authorities bundle, back up to, and we go now to a case which has been cited by my lord below, tab 10, Callahan. That was a case of property insurance where there was a fire damage.
Sorry, tab
10.
I think this goes back to what I was pointing to. It all depends on what the event insured against is.
Well, my lord, I'm now answering the question posed by my Lord Justice Moylan and the submission advanced by my learned friend, which is that you actually have to know, you have to crystallise lots before the indemnity responds, and therefore before the cause of action accrues. But that's just not right, because if you go to Sir Peter Webster's judgment, page 141 of the external pagination, your lordship will see referred to the decision of Mr. Justice McGaw in Pickersgill. I'm so sorry. The decision of Mr. Justice McGaw in Chandris, drawing on Pickersgill. And if we go to the second column, the last full quotation, His Lordship Mr. Justice McGaw, quoted by Sir Peter Webster, where the claim is for unliquidated damages, which of course any claim on an indemnity insurance is, it is not a condition precedent, it is not a fact that must exist and be pleaded, that the plaintiff has qualified the amount of his claim, or even that all the facts exist at the date of the writ, which enabled the proper amount of the claim to be determined. That such matters in a claim for unliquidated damages are matters of evidence, are not a prerequisite of a cause of action.
I think we're all agreed about that. Your cause of action under a policy of insurance accrues when the event against which you have insured takes place.
Quite.
And you are entitled at that point to bring a claim for unliquidated damages, whether you know you suffered a loss, whether you've quantified the loss,
quite,
or whatever.
And
so if the event insured against is, for example, fire or flood, and a fire takes place or a flood takes place, there's your cause of action. So we come back to the essential question of this policy: what is the event insured against?
And there are two answers to that. Well, your lordship have placed before you by counsel, by the parties, three possibilities. Possibility one is insolvency simpliciter.
Yes.
Possibility 2 is insolvency coupled with the, on an objective analysis, the obligation to pay more, even if you don't know how much that might be, and whether you know it or not. And alternative 3, which has multiple sub-alternatives, but they all have a single common theme, is the date when you've actually paid out the money, whether it's £1 more or you've completed the works, or variations on that. Those are the 3 options for this court. And the submissions I'm making now, and I've given you my first reason as to why it's either 1 or 2, but not 3. But not 3. And my lord, that leads to the second broad reason, which is going back to the relevant clause under the heading, I won't go back to it because you'll remember it, under the heading what we will do, NHBC do not say we will pay you the actual extra costs that you have in fact incurred. They say we will pay you, quotes, the reasonable extra costs above the contract price. So it's not incurred costs that are being insured against, it's reasonable costs that are being insured against. And if we go back to the judgment, tab 7, page 58 of the external pagination, paragraph 58, forgive me, which is indeed page 58 of the external pagination. His lordship, again, I suggest, fell into error when he said, last sentence, the limitation of the policies to reasonable extra cost is intended as no more than a cap on a claim based on actual costs. And I respectfully suggest that reasoning is incorrect. It is not a cap on actual costs incurred. It is a right of indemnity in respect of reasonable costs, not whether incurred or otherwise. They don't have to be incurred. And my lord, there's a decision of Judge Pelling in the Griffiths case, not on precisely the same facts, where again the same argument was raised. Does the limitation clause, the limitation period incept, does the cause of action incept from the date of actual expenditure, or does it incept from the date when the costs can be reasonably quantified? And Judge Pelling, in Griffiths, tab 17, Plunt, I'm speaking in summary terms.
You want us to look at that?
For the latter, yes, let's look at it. Tab 17. Page 317 and 318, external pagination. Paragraph 14, it is common ground, this is page 317, forgive me, column 2, common ground that the policy is an insurance policy. The defendant maintains that it is a policy of indemnity insurance. By the time of the hearing, that's common ground. The claimant claims, submits, therefore, that in the absence of clear words to the contrary, liability arises immediately and insured event is suffered as a result of the happening of an insured event. And then the words from Sir Peter Webster a little later on in the judgment of Callaghan are quoted. We might as well look at them now so I don't have to go back to Callaghan. The fact that well, I need your lordship to read that if you wouldn't mind. In the result, Sir Peter held that the indemnity insurance policy being considered by him was an agreement on which an insured conferred a contractual right on the insured, which came into effect for limitation purposes. Immediately a loss was suffered caused by the event insured against, and the cause of action accrued for limitation purposes on the date that the loss occurred, not the subsequent date when the law insurer avoided. And then 15, we look at, there are 2 clauses in the relevant policy, 3.2 and 3.3, which have been previously quoted at paragraph 8 at page 316, where what the underwriter promises to do under 3.2, for argument, just to take that, should indemnify the policyholder during the defects period against the cost of repairing, replacing or rectifying any defect.
So the event insured against was defects. under this policy.
Well, what is it could be said the event insured against is the cost of repairing.
Well, it could be.
That's what the claimants argue.
But what the judge decides is it's the defects which are the event insured against. So it's a property damage case.
But for my purposes, we go back to page 318, column 1, top of the page. The trigger for entitlement under the policy says the claimant is the incurring of costs, with the result that unless and until the insured has incurred costs in rectifying, no liability on the part of the defendant can start, and therefore time doesn't run.
That would be true if that were the event insured against, but the judge decides it's not.
Quite. Now, my lord, going back to my second reason, what is indemnified is the reasonable extra costs, not the actual extra costs. That takes me to my third reason, which is the when you can claim provision, which I've shown your lordships already. And if we go back to what his lordship said at paragraph 60, he considers that argument and says, no, when you can claim, that particular provision is a notification clause, page 58 of the external pagination of the core bundle. Last sentence, I accept Peabody's submission, the relevant part of he gave it a little, a letter very helpfully, is a notification or information provision, it's not an entitlement clause. And again, I say that was wrong. It is not when you should notify a circumstance. The heading is when you can claim. When you are entitled to make a claim, ergo when you have a cause of action in legal speak.
So just going back to one of the things the judge said, one of the possibilities he canvassed was that the administrator or receiver or whoever might continue with the building project. That was one of the factual scenarios. When you can claim in the box is that the contractor has not completed the homes. So if the receiver is continuing the project, can you claim or can you not claim?
There are complexities that arise on that particular scenario.
We're trying to understand what the policy means, Mr. Grant, and it's got to respond to potentially a variety of different circumstances. We can't tie it to the facts of this particular case because we're just trying to understand what it means.
Yes.
So if the project continues, because let's suppose a bank has step-in rights and continues the project, then can you claim?
Well, my primary case is that the insured peril is the insolvency.
That I understand.
That's my primary case. If I'm wrong on that, my secondary case, which is a case which is probably likely to be to engage 99.9% of claims under this policy, is that when there is is that the event insured against is the insolvency plus the obligation to pay more, and that's an obligation. I'm repeating myself, of an objective question, not dependent on actual expenditure. I'm not suggesting when you. I'm looking at all the various indicants as to when the cause of action accrues, and my third indicant is that in this case that is not a notification clause. It's a clause that says when you can claim, and in this case they could claim on the facts of this case. The contractor had not completed the contract as of the 29th of June. That's when you can claim. It doesn't say you can claim once you've spent £1 more. The fourth reason, my lord, is what we would say is the uncommerciality of the claimant's case. And we would say it is a perverse reading to say, on the one hand, it's absolutely vital that you can only seek indemnity once you've actually spent the money. But then to say, but no, you don't have to spend all the money, you just got to spend £1 more. So that once you've spent the £1 more, you've used up the tank, and then apparently on what the primary version of the case is set out by Mr. London at the least, at that moment, you can then claim for future costs because you've used up the tank. there is a variant, it's fair to say, which is, I'm not sure it's pleaded, but it's alighted to in my learned friend's skeleton argument, that in fact it actually requires final certificates in respect of all the trades. So the actual contract, the development has to be built out in its entirety, and that's a variant which would have pushed back the limitation period even further. And this court will have to consider that. So that the uncommerciality of the claimant's construction, the perversity, as we would respectfully put it, of saying it's important you have to spend the money, but only £1 more, and then there's a prognostication of the future taking place at that moment. And I haven't got time to develop the submission, but we rely upon and make reference to what Lord Justice Coulson said in Manchester about where, in that case, an argument was put that, well, you've got to spend the money. And the response is, well, you might have a situation where the insured just doesn't have the money. It is a cash flow question. And we say that it's not going to happen in every case. You know, the employer may be very well heeled. But that's a scenario it's worth and proper to consider, which is the employer, which has spent a lot of money on the original contractor. It's spent a lot of money. The contractor has left the property in a thoroughly defective condition, and that employer now has to go out and let out the contract to somebody else who may say, you need to pay a sum of money up front if I'm going to do this. The contractual works are in a terrible state, or what have you. But on my learned friend's case, he's not entitled to any form of money until he's actually paid out what could be very substantial additional sums. And we say that tells against that construction. The next point this is on uncommerciality, is that it creates the most potentially very complicated questions as to when the cause of action accrues. My learned friend spent some time saying it was all fearfully simple. Well, if your lordships have read Mr. London's witness statement, which is 16 pages devoted to adding up sums, multiplying them, or not multiplying them, but deducting them, and so on and so forth, it doesn't, from my point of view, and maybe a deficiency of my intellectual reasoning, it looks a pretty complicated business on the claimant's case to work out when the cause of action is accrued. And we say, and his lordship below himself said at para 29, it's a factually intensive and an extensive analysis would be required. And we agree. And we say that it is unlikely that contracting parties would have intended that kind of complexity of analysis would be required to work out the date of the cause of action. And my learned friend says, well, it doesn't really matter in this case because on any view we're within time on our analysis. But that's not the way to look at it. The claimant, an insured in any case like this, needs to know with precision and with ease when it can make a claim. And for the court to say the answer is you can make a claim by reference to the moment that you have paid out more than the underlying contract price, but that may require you have to deduct this and add that. Look at Mr. London. The claimant's going to throw up, the insurer's going to say, well, I want to know with precision when I can make a claim. I don't want to be met with NHBC saying, actually, your cause of action technically didn't accrue when you issued your claim form because you were 3 days in advance, and therefore it was a thing written in water. My lord, and my learned friend seeks to answer these points in his skeleton argument and says, oh, it's all fearfully simple. But I respectfully suggest that just anyone looking at Mr. London's evidence would see that it's anything but. The fifth point, my lord, is that on the claimant's case, it can mothball the project and revive it in 10 years' time, in 15 years' time, or 20 years' time, and the cause of action is just held in abeyance. No claim is accrued. So it can come knocking at my client's door many years later, and this is a realistic possibility on my learned friend's case. It may be that the claimant suffers an insolvency and thinks, well, let's forget about that. The defects are terrible. Let's devote our time to other projects. We can come back to that at some later stage. And on my learned friend's case, my client is on the hook, to use the vernacular, for years, if not decades, to come, and that's the Henthorne point.
Can I just explore that for a moment? Just a point occurs to me that we were talking about earlier on in your submissions, and that is the provision in the box that you can claim up to the date of the Buildmark choice certificate. Now, if I've understood correctly, the Buildmark choice certificate is a certificate given to the homeowner.
Exactly right.
So let us suppose that there is a project to develop 175 dwellings, 60 of which have been completed. So 60 Buildmark choice certificates have been issued to 60 homeowners. Can you claim for anything else? Was that? Can you claim for the remaining homes or not?
I think the way we plead
Was your cut off the moment the first Buildmark choice certificate is issued to a single homeowner? Is that the cut off date?
Well, this in itself gives rise to my sixth point, because the oddity of the claimant's position is that the cause of action on its case accrues after the Buildmark certificates have been issued, and therefore on its case the cause of action just collapses into a black hole, because I've shown you where the certificates were issued, when they were issued, 18 through to 20. On one version of my learned friend's case.
On your case, let us suppose that the contractor is supposed to build 120 dwellings. He builds 60. 60 Buildmark certificates are issued, and then he goes bust. Can you claim or can you not claim?
Well, on our case, you cannot claim after the issue of a Buildmark certificate, because that's what the contract says. And we say that tells very significantly against the construction proposed by the claimant, because it could lead to the preposterous outcome whereby, in fact, there is never a cause of action, because they've been, on one side, they've been pushed too far, on the other side, they've been pushed too far back, and it just never arises. We say that just can't be right. And the way...
But on your case, you're not really insured against insolvency, because you managed to build one home before you went bust.
Well, but no, but
so
no,
that's the end. That's the end of the insurance.
No, it's not. It's not. But in practice, it won't ever happen, because the home. Let's say there are 60 homes have been built out, and a Buildmark policy has been a certificate has been issued. That means that home is now complete.
Yeah.
So there's not going to be any more monies required to complete it.
But I want to insure against the rest of the project. That's why I took out that I wanted to insure the whole project. That's why I took out the insurance.
Yes, but this leads to the next point I was going to make, because it leads to a perverse outcome. My learned friend's argument leads to the outcome that its cause of action accrues after it has been contractually barred by an earlier provision, and the only way to avoid that perverse outcome, because we as insurers don't want to create situations where there's no possibility of a claim. That's why we say on this appeal, to avoid that perverse outcome, the cause of action has to be brought forward in time, so that the insured won't be met with, but you can't claim because the certificates have been issued, and that's debarred your claim. And well, if I can just give you the, if I can just.
But that interpretation doesn't accommodate a situation where the contractor goes bust after a Buildmark choice certificate has been issued.
But in that case, there won't be a claim in actual monetary terms, because the Buildmark certificate is a warranty that, and a statement that the properties have been built out in accordance with the requirements.
I don't understand that. If you've got a development that's going in phases, one phase has been completed, Buildmark choice certificates issued, and the other phase is still going on, and then the contractor goes bust.
Oh yes, you can claim for the subsequent. I'm not suggesting that the issuance of one certificate precludes an entitlement claim for, if home one has been built out,
yeah,
it gets a certificate. The certificates are issued not in one go; they're issued from time to time, as the annex to the defence shows.
Yeah.
So there still will be, if the contractor goes bust and there are still outstanding
right.
Buildmark certificates,
yeah,
then then of course you can claim for those.
Right.
But the scenario...
Where do we get that out of the words? You can only claim under the section up to the date of the Buildmark choice certificate.
But I think we would say...
You say that's distributively interpreted, and it's dwelling by dwelling. Do you?
I think it's... can I just... Because remember, there are separate policies. There are 88 separate policies. So a certificate, one certificate for one home, doesn't preclude a claim for the totality. Because let's say the builder has built out those 10 homes.
I hadn't appreciated that.
You've got
this is not for the project. This is each individual dwelling.
Well, there are separate policies.
Has a separate policy.
Yeah, they're in the bundle actually. Yeah, but on the claimant's case, on one version of its case, the cause of action only accrues when the final certificates have been served, and that could well be after the certificates have been issued. And in fact, I haven't got time to take you to it, but there is pleadings on this, paragraphs 3 through to 6 of the defence, and the responsive pleading and the reply, which involves my learned friends having to engage in a certain amount of mental acrobatics to get themselves out of the bind that their own interpretation places upon them.
It was really the question I asked before. Is the Buildmark choice certificate point a separate limitation defence? Because you say that the claim was only started after the date of the last Buildmark choice certificate.
It's not a limitation as regards the claim form. It's a limitation as regards the making of a claim, the intimation of a claim. Well, that's...
And a claim was intimated before the certificates, because we saw that in the emails.
Well, it depends. Well, there was a claim intimated in July 2017, which is before any of the...
Right. So,
but my learned friend says that was the thing written in water.
Yes. Well, that's a slightly separate point. But that sentence, under when you can claim that first sentence, you don't say gives rise in this case to a separate limitation defence, because the judge certainly hasn't opined on that.
We didn't bring this point before the court, but we have pleaded a limit. We have on the basis that the claimants are right. We have pleaded, whether it's a limitation defence or a bar to a claim. We have pleaded that at paragraphs 3 through to 6 of our defence.
But sorry, you say the relevant date is the insolvency.
Yes.
So the insolvency, the whole project, all the houses could have been completed easily within 6 years of the date of the insolvency. And all the certificates might have been issued. So what's happened?
There's a right to claim on the 29th of June.
Right, so the claim continues to be an effective claim which can be brought despite the fact that every home has got a Buildmark choice certificate issued in respect of it. So I'm not sure how this helps your interpretation.
No, it helps my interpretation by studying the case for the claimant, because the case for the claimant is that the cause of action only accrued in almost every case, bar about 2, after the Buildmark certificates were issued in respect of the various properties. And I mean, if that's what they were...
All the correspondence has been collective sums. It hasn't gone, house 88, this has had 15,000 spent on it, it's going to cost 85 to complete. It's looked at the project as a whole.
That's true.
Everybody's looked at the project as a whole.
That's true.
It's not house by house. It's, is it going to cost you more to complete the project?
That is, as a matter of practicality, that is true. But as a matter of construction of the contract, it says what it says.
I know, but it doesn't, as been asked, it's not an additional limitation defence because, as you say, the claim continues beyond the date of the issue of all the relevant Buildmark choice certificates. So how does the fact that certificates have been issued, not been issued, how does that help on the interpretation, on your argument of the... It
helps because it shows that the claimant's interpretation cannot be right. But let me try and simplify it if I can.
Please.
On the claimant's case, the cause of action at the earliest accrued when £1 more was paid, which on the claimant's case was at some point between March and September 2020, and your lordship has seen the blue line going back and forth on the diagram. An alternative case is that the cause of action only accrues when all the final certificates have been issued by the relevant contractors, which it puts at 2000, as I understand it, and 21. The bulk of the Buildmark certificates were issued prior to June 2020, and they were all issued prior to 2021. So on the claimant's case, we would say its claims are barred. Now, we don't just simply seize on that and say, well, great, we're going to trump you. We'd say that means it can't be right. Your interpretation cannot be right, because it means that the moment you acquired a right to claim was after you'd lost the right to claim, ergo it must be a perverse reading of the contract. It's as simple as that. But also, I'm going to have to move on because I've just got limited time.
Yes, I was going to ask, how are we doing for time?
Well, I was going to finish at 1. That's I mean, we've gone through a lot of the underlying material already, and I'm going to finish at 1 if that's convenient to the court. Yes. And I'm going to but that's my sixth point, which your lordship's question rightly took me to. But it is worth seeing how the defendant responds to that point in its reply, tab 12, core bundle. Because the only way it can get round this, page 116, para 8.3, is to say on the true construction of the policy, the words you can only claim under this section up to the date of the Buildmark certificate are clarificatory. And then they then, at para 88.4, are forced to try and plead an implied term to undo the potential negative consequences of that provision. My Lord, can I just go back to my fifth point, though, which was essentially the construction advanced and advocated for by the claimants means that the date of accrual of the cause of action is wholly in their hands. Now, the judge below received that submission from me. He dealt with it at para 61, page 58 of the external pagination, tab 7 of the core bundle. Bottom of the page, for completeness I note that NHBC submits it would be a rare outcome that a court would conclude that a claimant can itself dictate or choose to defer when time starts running, and then refers to Lord Newburger's dictum, which I've shown you, and indeed Judge Pelling made the same point in the Griffiths case, which we've looked at. I respectfully agree with that observation, although it remains a question of construction in any particular case what the insured peril is. But then this, over the page, it is not Peabody's case on the insolvency point that it can dictate or defer the timing. Now, I profess not to understand that. It's precisely the claimant's case. See paragraph 7 of their reply. It was already clear in their submissions at first instance, but it's become even clearer through their reply.
On the insolvency point. This is the artificiality arising from whatever arose at first instance. It's not Peabody's case on the insolvency point that it can dictate or defer the timing. Well, I read that as the judge, again, drawing the wagons round the insolvency point and saying that's all I'm deciding. That the dictating or deferring the timing arises out of the have to pay more construction, which the judge excludes from the insolvency point. Well, so that's how I read that.
Well, except this, the judge does go on to consider all the various arguments that I have deployed in the last 20 minutes on the interpretation of the have to pay more. And it is it was the claimant's case at first instance that the cause of action accrued when it had actually paid more. It didn't exclude that point from the judge, whether by way of evidence or submission, and it was a submission I made, and just the sentence, it is not Peabody's case on the insolvency point that it can dictate or defer the timing. Well, whatever the meaning of that, it is the claimant's case now, and overtly, that it can dictate or defer the timing, and it doesn't shy away from that. And I say that's a very powerful reason for concluding that its case, as pleaded at paragraph 7, is wrong. It is worth us considering how my learned friends deal with that point in their skeleton argument. It is paragraphs 56 and 57, tab 17, page 367. Under the heading, the postponed of the cause of action, at 56, they set out the contention that we've advanced in our skeleton argument. The answer is put in very pithy terms. The policies contain express terms which prevent this. NHBC is not responsible to pay the costs resulting from the insured's unreasonable delay in pursuing a claim.
Can you just show us where that is in the policy? Mr.
Yes, this is where my note it fails me. The policy is, of course, at tab 13. I'm sure my learned junior is about to give me the answer. I mean, it's a quotation from my learned friend's skeleton argument.
Page 138.
138. Thank you very much.
138.
Yes.
Yeah.
Oh yes, we will.
It is.
Yes, I follow.
But let's just consider that for a second. We will not be responsible for costs resulting from your unreasonable delay in pursuing a claim. But there are two points to be made there. The first is, on my learned friend's case, there is no claim until it chooses to unmothball the project and spend the money. So the claim only arises when it's paid at the earliest the £1 more. So delay up to that payment of the £1 more is irrelevant. But secondly, just putting that point to one side, which is a complete answer to the submission, all that paragraph 3 says is we won't be responsible for costs resulting from your unreasonable delay. Now, no one suggests, my point is not that if you leave it 15 years, somehow it's going to create an entirely different, it's going to increase my liability as an insurer. My point is we want to close our books on things. And there's always going to be the fixed 10% cap on indemnity. So this clause simply doesn't provide any answer to the mischief which is identified by Lord Newburger. The claimant might say, even if I'm wrong on my first point, well, look, we spent 15 years, we've waited 15 years, but there's been no inflation in the building market. It's just, we're still going to, the claim we make is the same, we're just making it 15 years later. But that doesn't meet my clients and any reasonable defendant's desire to make sure that claims are brought early and are not sort of postponed ad infinitum at the whim of the claimant. And it is the inevitable outcome of the claimant's case that it can dictate when it can bring a claim and when the cause of action accrues. My lords, those are the submissions we make as to why our interpretation is correct and my learned friend's interpretation cannot be right. That takes me to...
Just before we go on, can I just ask you about some other bits of the policy which I've had trouble quite understanding? If we can go to core bundle page 131.
Yeah.
We've got part C, which is home damage cover. And that clearly says that it applies if there's physical damage to the home. various reasons. So we've got that's what you might call plain vanilla property insurance. But under conditions and limitations, 3 up from the bottom of the right-hand column, it says you can't claim for something under this section if you can claim for it under Part B or Option 1. How would you claim under Option 1 for physical damage to the home? I don't understand that.
You can claim indirectly for physical damage in the sense that the typical scenario, no doubt, will be a contractor has started work on the development, it has put in some footings, it's built this, it's built that. It may well have built things in a thoroughly inadequate way, and indeed in this case, your lordships will have seen that the contract with Stack was not just for developing it out, but for remedying existing defects. So although the Option 1 cover does not in terms say we will indemnify you for damage, it implicitly does, because presumably if there is a defective construction, then it'll cost more to remedy that defective construction. But my lords, can I just say I've got to get through 3 more. Well, my lord, I've got to get to ground 5 as well. So I'm going to take things as quickly as I can now. In essence, my lord, I have covered ground 1. I have taken your lordships to certain of the authorities. I have not time to go through the authorities in a single tour d'horizon, so to speak. But what we suggest in our skeleton argument, what I advance before your lordship, is that the critical question is, and I accept this, is when the insured peril occurs. And we say that the best and clearest statement of the meaning of insured peril is to be found in Colinvo, Authorities Bundle, tab 24, which strongly support, this is page 420 of the external, quotes the Fanti, cites Callaghan, and says this, at the second hole punch, having quoted Lord Gough, it is clear that the statement should not be written in that way, for it is established that in the absence of wording to the contrary, a claim arises under an insurance policy as soon as the event which directly results in the loss has occurred, and not when the loss is manifested. And my lord, we say, and I think it's common ground that that's a correct statement of the law, that leads to primarily the conclusion that the insured event is the insolvency of the contractor. That is the event which directly results in the loss that has occurred. But in any event, it supports my secondary proposition, which is that the insured event is the insolvency which objectively leads to the need, not the obligation, not the legal obligation, but the need, if one wishes to build it out, to pay more.
And presumably
and
you would say the same thing applies to fraud, because that seems to be another insured event on your interpretation.
Yes.
So as soon as a fraud is committed, that's when the cause of action accrues.
My lord, yes. And of course there are multiple cases where insureds have come to before the court and said, well, I only incurred, for instance, there's an Irish case, a Northern Irish case we cite, where the insured said, well, I only suffered the business disruption loss at a period before 6 years after, within the 6 year period. And the answer was no, the insured event is the peril, as in that case, the break-in. The fact that you haven't suffered any loss, business disruption loss, doesn't matter. The event insured against is the peril. The cause of action accrues when the peril occurs, whether that causes loss or not. And that's the significance of Lord Bingham's or Lord Justice Bingham's statement in Kelly, which we cite, which is the distinction between the peril and the loss, and that can be easily transposed here, either to meet my primary submission or my secondary submission, but on either case, that should lead to my appeal succeeding and your lordship's rejecting, which your lordship should do for all sorts of other reasons, my learned friend's alternative submission. So, my lord, that essentially is ground one. Ground two I have, which is the burden of proof ground. I've already really covered that ground for much of that ground. It's worth just seeing how the judge responded to what is now ground two. Judgment, tab 7, paragraph 31 onwards. And it's really 35, page 54. 34 and 35. And my lord, we say, and I've already really elaborated this point, that it was for Peabody to articulate an arguable case that its claim was within time, not simply to rebut the defendant's case, albeit that case was elaborated and embraced alternatives in Ms. Alabi's second witness statement, and indeed in my skeleton argument, and it didn't do so. And without being able to take your lordships to it, my learned friend's analysis at paragraphs 82 to 86, we would respectfully say is simply wrong. My lord, ground 3 is to say, well, if it wasn't on either analysis the date of insolvency, then it must have been on a date sometime in late 2016 or early 2017. This is ground 3. And just the point we put in one sentence, your lordships will recall that email in February 2017 where there's a positive assertion we will have to pay more, and indeed considerably more than the 10% cap which is imposed upon us. And my learned friend says, no, there was no cause of action, no claim at that stage. And that can only be if he's right on the actual fact of paying a larger sum, the £1 more, or the other variance. And I think I can leave ground 3 at that. My lord, ground 4 was a ground that Lord Justice Coulson didn't give me vast encouragement to elaborate on. The reality is it falls away because we're now here having a debate, having a discussion, where I'm inviting your lordships to actually decide this point, decide what this term means. And it's quite wrong, and I'm not even sure it's suggested by my learned friend, that your lordships need any further evidence. I'm agreeing with the claimant's case for the purpose of the appeal on the facts. The question of what that means can be decided. Your lordships should grasp the nettle and decide the question. My lord, ground 5 is where I sit down and invite my learned friend Mr. Smith to elaborate ground 5. Unless I can assist you any further, those are my submissions.
Yes. Yes, Mr. Smith.
Yes, my lords. So the gist of ground 5 is that even if we are wrong on the construction of the policy, and Peabody is right to say that the cause of action accrued when you have to pay more in the sense of incurring actual expenditure, Catalyst in fact had to pay more in 2016 when it incurred site security costs in the form of removing squatters following the insolvency. And it follows, we say, that the claim for those costs, the site security costs, and I'll show you where those are in a moment, is on any view time barred. And on analysis, the whole claim is time barred because, and I'll develop this in a moment, option 1 gives rise to a single indivisible cause of action. And that case is underpinned by 5 propositions, which are as follows. First, option 1 provides that NHBC will pay the cost of reasonable precautions to secure the site. Can we just look at that quickly? It's on page 3-4 of the policy. my lord. So in the what we will do box, third paragraph, it says, in addition, we will pay the cost of reasonable precautions to secure the work defined in the building contract against unauthorised entry, theft and vandalism until work resumes. So that's proposition 1. Proposition 2 is that Catalyst had to pay more in 2016 because it incurred actual costs removing squatters and securing the site at that stage. And that's the claimant's case. So that's pleaded in paragraph 17 of the particulars of claim on page 76 of the core bundle. So we see there, following a tender process which started on or around the 28th of July 2016 and the removal of squatters from the site in September 2016, Catalyst engaged Stack to complete the works. And that was elaborated in a letter from Catalyst in January 2018, which is in the supplementary bundle at page 309. And we don't need to. I won't ask your lordship to go to a review of the time.
309.
It's page 309,
Thank you.
and it states in that letter that costs were incurred in 2016 removing squatters from the site. That's my second proposition. Proposition number 3 is that Peabody claims a proportionate part of those incurred costs as part of its claim to be indemnified in these proceedings. So if we look at Schedule A to the particulars of claim, tab 2, page 6 of the supplementary bundle.
So in the supplemental bundle now?
Yes. So this is the schedule setting out claimant's loss and damage, and on the second page of that, we
Site
have
security 56,000.
quite right, my lord. Yes. So that forms part of the claim to be indemnified. Now, proposition 4 is that, in light of that, even if Peabody's, the claimant's construction of the policy is right, its claim for site security costs accrued in 2016. And I say that because the costs were covered by option 1. It became necessary to expend them in 2016, and they were in fact expended in 2016.
Which is when you would expect these sorts of costs to be incurred because the site would be left vacant until the new contractors moved in.
Yes, my lord.
Yeah.
And so if Peabody had issued a claim form in 2016 for site security costs which it had in fact incurred, then NHBC could not have defended that claim on the basis that no cause of action had accrued. And insofar as my learned friends maintain otherwise, we say that's wrong.
Well, couldn't they have argued that they haven't had to pay more to complete the building, because that's what the contract is covering?
Well, no, my lord, because the security costs are additional costs which they wouldn't have had to incur but for the insolvency.
Well, doesn't that depend on whether they can find a cheaper contractor to build the project out?
No, my lord. It doesn't depend on showing. This doesn't depend on the what I might call the £1 more point, because I'll come to this in a moment. But the way the policy is worded, it's additional construction costs over the original building contract price are covered, but site security costs are a separate head of indemnity which are covered separately. So the cause of action accrued then, in my submission in 2016.
On the assumption that, because this wouldn't otherwise have been something that was necessary if the project had continued under the original contractor. It was per se an additional cost.
Yes, that's my law precisely, and that is actually how it's put in my learned friend's skeleton argument at paragraph 71.1. So this is tab 70. 70.1, I should say, on page 371. And we're told that there are a number of what are described as potential answers. But the first primary potential answer we're given is that the cost of reasonable precautions to secure the work are part of the additional costs recoverable under option 1 as a whole and do not give rise to a separate cause of action. And then it said that cost forms part of the overarching analysis as to when the insured has to pay more to complete the works, semicolon, but because such cost would not have been incurred but for the insolvency, it is inevitable that it will be recoverable, and that is the point which my Lord Justice Coulson made a moment ago.
Yeah. Yeah.
But my Lords, we go further than that, because we say that the claim under option 1 as a whole is time barred on this basis, and this is my final proposition, because option 1 provides for a single and indivisible cause of action to be indemnified, and we see that from the way option 1 is structured, because as your Lordships have seen, and we should look at it quickly at page 134 again, we have the heading when this section applies at the top of the page, and then we have a heading when you can claim, and your Lordship spent some time looking at those headings with my learned leader. Then you have a box saying what we will do, and in my submission that means what we will do when this section applies. So the heads of indemnity set out in that box become payable on the occurrence of the insured peril, whatever the definition of the insured peril is. But we say that the insured peril is the event of insolvency.
Yes, I understand that.
Per se, of course. So we say that the right to the cost of reasonable precautions it's not a standalone right sort of floating in the abstract. It's tied to the insured peril. There's a single cause of action, of which that is but one of the heads of indemnity. And so if the cause of action accrued in 2016, then that covers the whole of the claim under option 1 and not just those specific costs. Now I'm very conscious of the time, my Lords. I have one authority,
Right.
Which is an extract from Collinvoe and Murray, which is at tab 24. And on page external pagination 422. So, first sentence, the general rule here prevails. The occurrence of the peril is the event which triggers the insurer's liability, as that event puts the insurer in breach of contract and liable for unliquidated damages. That much is uncontroversial. But then the second paragraph, it was held in Banchoraig and Great Lakes, and that's the Northern Irish case to which my learned leader referred in argument.
Yes.
That the accrual of the cause of action for a business interruption claim is the date of the occurrence of the insured peril that triggers the running of the indemnity period. That decision is undoubtedly correct. While it may be said that losses continue during the indemnity period, there is no logical means of dividing the loss into separate claims. And the real issue is post-peril quantification of a single loss arising from the occurrence of the insured peril. Now, we say the same reasoning applies here. And whilst Peabody might incur loss in different forms and at different times, that's just a question of quantification. The cause of action under option 1 arises when the insured peril occurs. Now, I should acknowledge that before I move on, the authors, the learned authors, do then go on to refer to the decision of the lower court in this case.
And Professor Merkin's not shy about criticising decisions he thinks are wrong, and he doesn't seem to do it here.
No, my lord, he doesn't. But in my submission, the authors have misunderstood our argument,
Right.
because they say it was suggested that Van Craig was authority for the rather wider proposition that if there are claims under 2 or more sections of a policy, then there is just one limitation period applicable to both. But that's not our case. Our case is that
Your case is option 1 provides for a single cause of action. Part C might provide for a different cause of action.
Precisely, my lord. Precisely. I'm not sure how I'm doing on time. I have a couple of points on my learned friend's skeleton argument. If I can make those very quickly, but then I.
All right, make them.
So,
Peter, you okay?
paragraph 67. My lords. Page
67.
370. And the point on this is just that the respondents misunderstand our case, because they say, by ground 5, NHBC says that even if it's wrong about the insolvency point, such that the cause of action accrued at some point later than the insolvency advantage, the cause of action for precautionary site security costs expended by Peabody in 2016 accrued on Vantage's insolvency, and that because this claim is an indivisible part of the claim for additional costs, the whole claim must fail. But as I've explained, that's not our submission on ground 5.
Yeah.
So that misunderstands our case. In paragraph 68, it said that the judge had no material evidence about the costs.
Well, that's just a grumble, which seems to be abandoned at the end of the paragraph.
Yeah, yes, my lord. Yes, it's their pleaded case that these costs were incurred, as I've shown your lordships. Paragraph 69, again, this misunderstands our case because it says the 2 different losses cannot both be part of a single indivisible claim, but also give rise to 2 separate causes of action. Well, that's not our case. Our case is that there's one cause of action. And I've already shown your lordships paragraph 70 and paragraph 70.1, which I say is consistent with our case. Paragraph 70.2 addresses the hypothesis that there are 2 causes of action, and all I say about that is that it's not our case, but even if that were right, the claim for site security costs would on any view still be time-barred. So, my lords, those are my submissions.
Yeah. I'm sorry to put another question to you, because I've just been thinking about this Buildmark choice certificate point. When I raised it, I think Mr. Grant, prompted by you, said, well, there were separate policies for each of the dwellings. So, looking at securing the work in the what we will do box, we will pay the cost of reasonable proportions to secure the work defined in the building contract. The building contract is the project as a whole, isn't it? Not dwelling by dwelling. So how does that fit with this Buildmark choice certificate? I don't understand the relationship between those 2 bits of option 1. And if you want to come back at 2 o'clock with an answer, that's fine. But because what we will do seems to be looking at the project as a whole, however it's defined in the building contract, which I take to mean the contract between the employer and the contractor, whereas the Buildmark choice certificate, you've been saying, no reason to doubt it, is the certificate given to the homeowner of the individual home which has been built, even if the project is still ongoing for other phases of the development.
My lord, yes. Can I come back to my leader come back to you at 2 o'clock?
By all means. Right. 2:05.
All right.